Okay, so we were talking about high risk AI referred to in article 6 clause 2. Okay, so that sends us to annexure 3, and in the last class we had already completed until the half of somewhere this, right? So we had already completed somewhat of this. Now we continue talking about right. So we were talking about this access to and enjoyment of essential private services and essential public services and benefits we had talked about until here. So AI systems intended to evaluate and classify emergency calls by natural persons or to be used to dispatch or to establish priority in the dispatching of emergency first response services, including by police, firefighters and medical aid, as well as of emergency healthcare patient right systems. So essentially we are talking about, so for example, let's say there is a case in which, so let's say at the police station I have got just one resource. So there is just one vehicle that can go to some place. Now they receive two phone calls from two different locations altogether at the same time that some crime has happened, and immediately assistance of police is required. Now in such a case, if AI is used to decide whether police should go to location 1 or location 2, then this clause says that that is a high risk, because it says dispatching of emergency first response services including by police. So which location should police go to? If this is decided by AI, then that is high risk. Similarly for firefighters, if let's say I have got just one fire vehicle available with me, now if there is a fire erupts at two places, two completely different locations, and I must choose to go to one only, then even in that case, if AI is used, right, if the output of AI is used to decide which location should the firefighters go to, then that is also classified as the high risk AI. Similarly for the medical aid services and so on. So AI systems intended to be used for risk assessment and pricing in relation to natural persons in case of life and health insurance. So we know that in absence of any law regulating this, most of the insurance companies are just trying to predict in the back end that when will the person that is looking for the insurance is about to die. I mean at a very coarse level. So what we are saying here is insurance companies are already doing some kind of analysis on the overall health of a person, right? Apart from the test that they are doing, they are also kind of analyzing it through machine learning and so on. So if AI system intended to be used for risk assessment and pricing in relation to natural persons in case of life and health insurance, then so if you want to use AI there, and if you let's say want to say whether a particular person is so let's say if insurance companies want to assign more risk to a particular person, in the sense that particular person is more susceptible to death for whatever reasons, if AI is used, then that is high risk. Okay, so note that it is not prohibited, it is just high risk. That means a conformity assessment has to be done the way this particular act mandates. Law enforcement. So now we change the topic, we come to law enforcement. So this says law enforcement is high risk. So if you want to use AI in law enforcement, that is high risk. That's it. Insofar as their use is permitted under relevant union or national law. So we have seen that the in this risk pyramid, the level of high risk is below the prohibited one. So unless something is prohibited, so if an activity of law enforcement using AI is prohibited, of course it is prohibited, right? There is no question there. Now, but if something is permitted, then that thing comes under kind of high risk AI. Okay? So AI systems intended to be used by or on behalf of law enforcement authorities or by union institutions, agencies, offices or bodies in support of law enforcement authorities or on their behalf. So this is something that is going to get repeated almost everywhere now. So we need to start reading from here now. To assess the risk of a natural person to become a victim of criminal offences. Right? So if you want to assess the risk of a natural person to become a victim of criminal offences, then that is high risk. That means as an AI, so that means if police wants to use AI, then that among my population of 100,000 or among population of 1,000 people in my area, who is going to be a victim of a particular or whatever kind of crime. Okay? This is high risk. So they say it's not prohibited altogether, but and so one can also come and say, see, it's a good thing. It's a good thing that if police wants to use AI to find who might be a potential victim of some kind of criminal offences. True. But the kind of trauma that the person will go through and the kind of inconvenience that the person may have, right? It is simply not acceptable to allow law enforcement to do it as it is, right? So if law enforcement in a population of 1,000 has to go to 1% and wants to say that, see, your life is at risk, somebody wants to, let's say, harm you in whatever manner, then they want to do something. Okay? Now before police is able to say that a particular person is at risk, they should be able to make sure that the AI that they are using is doing the right thing. And this process of making sure that the AI is doing the right thing is essentially called the conformity assessment in this act. So it's a high risk activity by law enforcement. So the first thing is it is allowed. Second, it is high risk. That basically means that you have to follow some kind of procedure where all checks and balances for the AI that you are using are in place. So even though it's a good thing, but idea is these days everybody is doing AI for the sake of doing it. So this sloppy approach is basically not allowed. You have to be rigorous, you have to be really reasonable in what you are doing. You just can't say that you are going to be a victim of something and hence we take whatever further steps. AI systems intended to be used by or on behalf of law enforcement authorities or by union institutions, bodies and agencies in support of law enforcement authorities as polygraphs and similar tools. So polygraphs and similar tools, all these things have been already used by law enforcement. Side effects, their effects, they are already calculated, known, right? But now if police or if the law enforcement wants to use AI in all these tools, then again that becomes high risk. See, high risk is nothing special. From what I understand, high risk just wants to say that this regulation says if you want to make AI for a particular application which is classified as high risk, then you have to be really rigorous and in a way you should know what you are exactly doing and you should be accountable for what you are doing. This is all it means. High risk means your application will be better scrutinized. It must make sure that it is doing what it is doing in a fair and correct manner and so on. AI systems intended to be used, so we start from here. So we read from here. To evaluate the reliability of evidence in course of investigation or prosecution of criminal offences. So, if law enforcement and the other related authorities want to evaluate the reliability of evidence in the course of investigation or prosecution of criminal offences, then even that thing is placed as high risk. So, we are just talking about police at the stage of investigation or prosecution of criminal offences. Okay. So, the police they can use, but it is high risk if they want to evaluate the reliability of evidence in the course of investigation or prosecution of criminal offences. That means during investigation and post investigation period as well, when they are prosecuting the criminal offences. AI systems intended to be used by law enforcement authorities on their behalf, okay, right, for assessing the risk of a natural person of offending or re-offending. Right? This is in normal terms what we call as predictive policing. So, if police or law enforcement authorities in general, they want to assess the risk of a natural person of offending. So, if police wants to assess risk of a particular person, whether this person will become offender, will do a criminal offense or not, if the police want to assess it for a person, it is not prohibited, it is high risk. That means the AI that is being used to do the assessment, right, it has to be really kind of foolproof. It has to go through all these checks and balances given in the act. Or re-offending, not solely based on profiling of natural persons. Now, here comes the catch. So, if police wants to, or if law enforcement authorities want to assess the risk of a natural person of offending or re-offending, then that is high risk. But later it says not solely based on profiling of natural persons as referred to in Article 3(4) of the GDPR, or to assess personality traits and characteristics or past criminal behaviors of natural persons or groups. So, we will read it before that. Now, offending not solely based on profiling of natural persons. Okay. So, authorities, they can assess the risk of natural persons of offending or re-offending, that is high risk, but they can, but they can't do solely based on profiling of natural persons. So, if they do this just based on profiling of natural persons, then you can kind of deduce from this that it is basically prohibited. Okay. So, assessing the risk of natural person of offending or re-offending is allowed, is high risk AI, but it should not be solely based on profiling of natural persons, where profiling is actually defined in this particular article. We won't go into that, but we understand the general meaning of profiling. So, to assess the risk of a natural person or to assess personality traits and characteristics or past criminal behavior of natural persons or groups. Now, AI systems intended to be used by or on behalf of law enforcement authorities. So, we again read from here. For profiling of natural persons referred to in Article 3(4) of GDPR in the course of detection, investigation or prosecution of criminal offences. So, basically again, if AI is to be used for right. So, we must read these two things together. Now, if you see here, assessing the risk of natural persons or offending or re-offending, this is high risk provided it is not done solely based on profiling of natural persons. If it is solely based on profiling of natural persons, then that may not be allowed, that might be just prohibited. Now, but here if you see in this subclause, they say AI systems intended to be used by for profiling of natural persons. So, here it says, this part F says profiling of natural persons is basically high risk. Okay? It does not prohibit as such, but you will have to see that the act that is being done is different from here. So, here is to assess the risk of natural persons of offending or re-offending. Now, in this case, for profiling of natural persons as referred to in article 3(4), in the course of detection, investigation or prosecution of criminal offences. So, if police is, so if law enforcement authorities are doing some kind of profiling of natural persons in the course of detection, investigation or prosecution of criminal offences, then that is high risk. Note that no assessing the risk of a natural, so no predictive policing is going on in this case. In this case, it is just being said in the course of detection. So, if AI is used, if profiling is used for detection, that is okay. Investigation or prosecution of criminal offences, there if authorities want to profile natural persons for these purposes, then it is high risk AI, that means not prohibited but allowed only for these purposes. Still, if the police want to assess the risk of a natural person of offending or re-offending solely based on profiling of natural persons, that is still not allowed. So, point 7, we come to now migration, asylum and border control management, insofar as their use is permitted under the relevant union or national law. So, wherever this phrase comes, insofar as their use is permitted under relevant union or national law, this essentially means that if there is some other regulation, if there is some other act that prohibits something, then of course this act cannot permit that, right. So, there is something that is already prohibited in a particular jurisdiction, and if new law stays silent about it, then this basically means that that thing remains prohibited. So, it explicitly says insofar as their use is permitted under relevant union or national law. So, migration, asylum and border control management. Migration basically means, so if a person A goes from India to US or to Europe for the purpose of higher studies, that is also migration. If somebody migrates to other place for working, that is also migration, right. Asylum, the way we see it, right. So, if you remember, Julian Assange was given asylum by the embassy of Ecuador in UK. Border control management. Whenever we pass through airports and whenever we enter a new jurisdiction where passport control is there, we are talking about more, so that becomes an example of border control management. Of course, it does not happen just at airports, it happens at various other checkpoints too, but that is just an example. Now, AI systems intended to be used by competent public authorities as polygraphs and similar tools. We have seen this before. Police can't use AI in case of polygraphs and similar tools. Sorry, when I say can't use, it basically means they can use, but it is high risk. So, the whole process of conformity assessment and everything has to be completed. So, AI systems intended to be used by competent public authorities as polygraphs and similar tools in these use cases is high risk. AI systems intended to be used, okay. So, to assess a risk, including a security risk. So, something similar that we had seen for law enforcement agencies. Now, we know that law enforcement agencies, they have a border, they have They are well-defined jurisdictions, they work inside that. Now, law enforcement agencies may be different in this case. So, kind of same things, same principles will come in. So, to assess a risk including a security risk. So, if a person who is looking to migrate, seek asylum or is crossing through the border control management, all these authorities that are examining him or her, they can use AI to assess a risk including a security risk, a risk of irregular migration or a health risk posed by a natural person who intends to enter or has entered into the territory of a member state. So, basically it does not matter whether has entered or who intends to enter. So, whether you are outside the jurisdiction of a particular member state or whether the person has entered, it does not matter. This thing applies equally. What applies equally? If you want to assess a risk, so if a person A migrates, now these authorities, they can use AI to assess risk, but that is high risk AI, including a security risk. So, whether person A is whether a person A who is looking to migrate or seeking asylum or crossing through a border control management, it is high risk if AI is used to assess the risk of that person, including the security risk, whether this person is going to pose a threat to the security. A risk of irregular migration, whether the person has, so the person A might, so these authorities might be skeptical of whether the person A has crossed the border genuinely or not, or whether the person is an illegal migrant. It does not matter. AI system used to assess such a risk is classified high risk AI or a health risk. So, posed by a natural person, right? So, even if for a health risk, so AI can't be, so for example, if a person A who is crossing the border and is met by these authorities, they can, so it is high risk AI to use AI to determine the health risk coming from that person. Okay. So, for example, a concrete example might be, if a person A is trying to cross border and is dealt by these authorities, they can't use AI to assess whether a person is suffering from HIV or whether a person is suffering from COVID, right, and so on. AI systems intended to be used by or on behalf of competent public authorities or by union agencies, offices or bodies to assist competent public authorities now for the examination of applicants for asylum, right. So, examination of applicants for asylum, if these authorities want to do it using AI, then that is categorized as high risk. That means use is permitted, but extra amount of care, accountability has to be demonstrated. This is what we mean when we talk about high risk AI. So, for the examination of applications for asylum, visa, residence permits and associated complaints. So, even if you have some complaints in this process, it is high risk AI to use AI for examination of those purposes too. With regard to the eligibility of the natural persons applying for a status, one of these one, including related assessment of the reliability of evidence. So, we have seen that if you want to use AI in assessing the reliability of an evidence, then that is already high risk. This just emphasizes that, re-emphasizes that same old thing, that if you want to use AI in assessing the reliability of an evidence, then that is high risk. Continuing, so AI systems intended to be used by, okay, we start from here. In the context of migration, asylum and border control management, for the purpose of detecting, recognizing or identifying natural persons with the exception of verification of travel documents. So, it is not high risk AI to use AI for verification of travel documents. So, if you go and your passport is scanned using AI, that is okay. There is no high risk in that. But if it is for the purpose of detecting, recognizing, identifying natural persons, then that is high risk. That means facial recognition software, if it is to be used, remember that it is permitted, but if it is to be used, it is high risk, has to go through all these parameters that the Act has specified. So, for the purpose of detecting, recognizing and identifying natural persons. Now, we come to the last point given in Annexure 3. Administration of justice and democratic processes. So, AI systems intended to be used by judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts. So, if you want to use AI in researching and in interpreting facts, now in this case you are a judicial authority and in democratic processes too. So, this part applies to judicial authorities and this part applies to democratic processes. So, in researching and interpreting facts, if you want to use AI, that is high risk. And the law in applying the law to, and if you want to apply the law to a concrete set of facts, high risk AI, or used in a similar way in alternative dispute resolution. So, wherever you are going to, wherever you have this judicial authority, be it through the courts or be it through the alternative dispute resolution mechanisms, if you want to do research, interpret facts, in applying the law to concrete set of facts, then that is high risk AI. Use is permitted, but it is high risk. Now, AI systems intended to be used for influencing the outcome of an election or referendum or the voting behavior of natural persons in the exercise of their vote in elections or referenda. Right? Now, before we take this one in detail, let us talk about the next sentence. So, this does not include AI systems whose output natural persons are not directly exposed to, such as tools used to organize, optimize and structure political campaigns from an administrative and logistics point of view. So, if you want to use AI, क्या हुआ? Okay. So, if you want to use AI, so you are a politician, if you want to use AI to organize, optimize and structure political campaigns from an administrative and logistics point of view, that is allowed. What is not allowed is, so again see, I am frequently making this mistake of calling it not allowed. So, even though I am correcting it every time, but allowed, but it is high risk. So, AI systems intended to be used for influencing the outcome of an election or referendum or the voting behavior of natural persons in the exercise of their vote in elections or referenda. However, I do not understand why is this high risk. I find this should be prohibited. So, AI systems intended to use for influencing the outcome of an election. If you are using AI systems to influence the outcome of an election, I am unable to understand why should this thing be allowed, right? Or referendum or voting behavior of natural persons. So even if you use AI to, influence the voting behavior of natural persons, they say it is high risk and not prohibited. I am not able to get that, so maybe you can help me understand that. Okay. In the exercise of their vote in elections or referenda. To me, this looks like too much dangerous. It poses too much threat to democracy. This should be prohibited. I mean, this is not high risk. That is something I understand. So this is not high risk. But this, in my opinion, is not high risk. This is something that is above that. It should be prohibited. So with this, we are done with the annexure 3. Now we come back to Article 6, right? So we had directly gone to part 2. Now we talk about a little bit about every other thing here. So I'll just say that if something, so if AI system is intended to be used as safety component or product, or the AI system itself is a product covered by the union harmonization legislation listed in annexure 2, right, then that is high risk. So basically, or if it requires this conformity assessment under the third party conformity assessment, is required to undergo the third party conformity assessment with a view to the placing on the market or putting into service, then that thing is also high risk AI. So loosely speaking, if something falls in annexure 2 and if that is used as a safety component or a product itself as AI in those systems, in those legislations, in those regulations, then that is high risk. So I won't be going through the list of annexure 2 now. So by derogation from paragraph 2, the one that we just covered with annexure 3, by derogation from paragraph 2, AI systems shall not be considered as high risk if they do not pose a significant risk of harm. See, even though the list provides very wide coverage of high risk AI, this clause comes and says it will not be considered, the AI will not be considered high risk if they do not pose a significant risk of harm to the health, safety and fundamental rights of natural persons, including by not materially influencing the outcome of decision making. This shall be the case if one or more of the following criteria are fulfilled. So the AI system is intended to perform a narrow procedural task. So for example, law enforcement, you might be doing some big thing, and in that you are using a small narrow procedural task, procedural, remember it is procedural here, task through AI, right, managing something, then that is not as such high risk. So the clause 2 gives a list of annexure 3 that says these things are high risk AI. 2A comes and says it starts with those things are high risk AI, but there are some exceptions in which, so basically a more balanced approach is taken for this AI risk. Now AI system is intended to perform a narrow procedural task in a high risk thing that should be allowed in principle, and of course it will take, so do not pose a significant risk of harm. This is something that is left up to the courts to decide. So AI system is intended to perform a narrow procedural task. AI system is intended to improve the result of previously completed human activity. So, if AI system is used to improve upon something, for example, if as a company you want to see the safety of your, so you offer adventure sports, for example, bungee jumping, and so 10,000 people have already completed bungee jumping, and now you want to do some kind of AI on their data to understand whatever, okay, then in that case it is not high risk, because the AI system is intended to improve the result of a previously completed human activity. Okay, AI system is intended to improve the result of previously completed human activity. Right. So let's say if at border control management, some activities that have been previously completed, right, but if AI system is intended to improve those results, then that should be okay. I am not able to think of a concrete example in this case, but I don't think this should be very difficult to understand either. So, because the nature here is not to predict something, so we are not looking, we are not peeping into the future. So, we are not using this, predictive power of AI. Rather, we are going retrospectively and see what can be done to improve the result of previously completed things, right, and completed by human activity. AI systems intended to detect decision making patterns or derivations from prior decision making patterns, and is not meant to replace or influence the previously completed human assessment without improper human review, right. So, firstly, without improper human review, it does not prohibit anything. It simply says if there is a proper human review, then you can still do this. So, AI system is intended to detect decision making patterns or deviations from prior decision making patterns, and is not meant to replace or influence the previously completed human assessment. So, if AI is not meant to replace or influence the previously completed human assessment, then that should be fine. And even if it is done so but with proper human review, then that is also fine. Intended to detect decision making patterns or deviations from prior decision making patterns, so that should be allowed. AI system is intended to perform a preparatory task to an assessment relevant for the purpose of the use cases listed in Annexure 3. The AI system is intended to perform a preparatory task, right? Just a preparatory task to an assessment relevant for the purpose of use cases listed in Annexure 3, the list of high risk that we have talked about. So, if it is just used to perform a preparatory task, remember, at a very high level, high risk usually tries to model or to capture those activities where the predictive nature of AI is being used. If you want to use the power of AI in assessing something that is already completed, then that should not be high risk, is what this paragraph broadly says, right? Or if you want to do some preparatory task, that should also be okay. Now, this proviso comes and says, notwithstanding whatever, AI system shall always be considered high risk, not prohibited, if it performs profiling of natural persons. Now, so the providers who consider that AI system referred to in the list in the Annexure 3 is not high risk, they shall document their assessment before that system is placed on the market or put into service. Before that system is Okay. Such providers shall be subject to the registration obligations set out in Article 51A, and the provider shall provide the documentation of the assessment upon the request of national competent authorities. All this says, if you as a provider think that your application is not covered by high risk AI, then you have to basically go through this registration obligation provided in Article 51A. You have to do the assessment, document the assessment before placing the system on the market. And the Commission and AI Board is basically given more responsibilities to give concrete, so provide guidelines specifying the practical implementation of this article, which is Article 6, by a comprehensive list of practical examples of high risk and non-high risk use cases on AI systems. So, we are yet to see a complete closure of this act, because there are so many things that are bestowed upon the Commission or the AI Board or the AI bodies that are made under the AI office basically. The Commission is empowered to adopt delegated acts. So, this act will require much more on top of it. So, the Commission is empowered to do those delegated acts. So, since these are part of the commissions, we just do not go there in this short course. So, basically some power of delegated acts given to the European Commission. But all these things are simply saying that whatever delegation is done by European Commission, it does not have the superpower to decrease the overall level of protection of health, safety and fundamental rights in the Union. So, AI, use it, allowed, but as long as it does not harm natural persons, it does not decrease the overall protection of health, safety and fundamental rights in the Union, whatever you do should be allowed. We talk a little bit, maybe 2 minutes about Article 7. So, Commission is empowered to adopt delegated acts in accordance with Article 73 to amend Annexure 3. So, Annexure 3 we saw is the list where all these high risk AIs were listed. So, the Commission is empowered to adding or modifying the use cases of high risk AI systems where both of the following conditions are fulfilled. So, let us not go into the exact conditions because that is up to the Commission to look at, but what we are simply saying here is Article 7 says so Annexure 3 is not a fixed list, it is dynamic and the Commission is empowered to add or modify things in it. So, the Commission shall take into account the following criteria. Again, since it is part of the European Commission, we do not really want to go and read all these things line by line. And finally, in the last clause, they say that the Commission is also empowered to basically remove high risk AI systems from the list provided in Annexure 3, provided some conditions are fulfilled which are listed here. So, with this we finish Article 6 and 7 and we will now be looking at Chapter 2 of the same title 3, which is high risk AI. What are the requirements for high risk AI systems? Okay. So basically, once an AI is classified as high risk, what is required to be done now from the mainly the providers of it? Okay. So that's it in today's class. Thank you.